Senator Graham.
Thank you, Mr. Chairman. One of the observations about this whole debate is how diverse the states seem to be in terms of arriving at the same conclusion, where you have Michigan, Nevada, New Hampshire, and Pennsylvania with stand your ground laws, and you have a lot of southern states where I guess the point I'm trying to make, it seems to be that Democrats and Republicans, depending on what state you're from, seem to embrace these laws. 8 Democratic governors have signed in to stand your ground laws, so I don't hope this doesn't turn into the Republicans are for it and the Democrats are against it. It seems to be a pretty diverse mix of views about whether or not this is good public policy. Mr. Sullivan, from the federal point of view, there are remedies available to the federal government if there's been an injustice at the state level. Is that correct? Like in any case, the Trayvon Martin case, the case here in Illinois, the Justice Department could, if they chose, pursue federal action. Is that correct?
Absolutely.
Do you agree with Attorney General Holder's decision not to pursue a federal civil rights case in the Trayvon Martin?
I do, based on the standard that needs to be satisfied in order to move forward with a case like that. The federal government would have to demonstrate that at the moment of the violent encounter, Mr. Zimmerman behaved as he did as a function of racial animus, and I'm not sure that there's sufficient evidence there for the federal government to go forward. So I tend to agree with that case on that, with that decision on that basis, and also on a more prudential basis that the federal government should be cautious and exercise discretion in going in and upsetting a state verdict.
I think that's a very, I agree with you. I hope I'm not hurting your reputation in the legal community, but
you've enhanced my reputation, Senator.
I'm honored that you would say that, but I think that's a pretty reasoned view, because I know there's a lot of pressure being applied to the Attorney General and, quite frankly, the President. And, you know, we're talking about trying cases in political arenas is probably not a good idea, but having victims speak up, having mothers speak about losing their children, that is very appropriate, and I hope we'll listen and learn where we can. If you were defending a case like the Trayvon Martin case, would you have done similar things as the defense?
You'd have to be a little more specific.
Was there anything wrong about the defense in that case? Anything unethical?
I'm not going to charge a fellow lawyer with unethical behavior without knowing more. I was deeply troubled by the caricature of Trayvon as the personification of a stereotype. Trayvon Martin as thug, Trayvon Martin as criminal. I was deeply troubled by that overlay over the criminal justice system. Whether that violated Florida's professional rules of conduct, I do not know. I haven't studied them with any detail in order to make that sort of claim. That I would not have done. I will say that—
You ever defended a person accused of rape?
Personally? Mm-hmm. Oh, I have.
Have you ever questioned the victim?
I have.
And I guess the point from Ms. Martin's point of view, your son was a fine young man. I mean, I'm trying to sit there and think as a parent listening to all this in court, how I would feel. But I've been a defense lawyer. And, you know, the person expects you to vigorously defend the interest of the client. And that's why we have rape shield laws. We're trying to get that balance between how far can you go in attacking the victim to protect the rights of the accused. And in terms of the racial implications of that case, I think they're raw and they're obvious. But, Mr. Plott, it seems to be, from an objective point of view, that stand your ground laws tend to apply. Well, most violent crime is within the community itself. Is that correct?
That's exactly right.
Yeah.
And
I'm just trying to come to grips with the idea that somehow this law has a racial injustice about it. And I mean, do you think it does, Mr. Sullivan?
I think the impact of the law has a disparate racial tilt, and that troubles me profoundly. That stand your ground was used in this particular case. If I can just amend what Senator Cruz said, it's not entirely correct to say that stand your ground was not part of this case. Mr. Zimmerman did not avail himself of the immunity portion of stand your law. However, the judge instructed, consistent with Florida law, which included an express statement of stand your law. If you feel that you were imminently in fear of death or reasonable bodily injury, then Mr. Zimmerman had a right to, quote, stand his ground and use deadly force in response. I may have cited it in my written testimony. If I didn't, I'll provide it to the chair, the specific jury instruction. So stand your ground was front and center in this case, just not the immunity portion of stand your ground.
Mr. Lott's rendition of statistics were pretty compelling, and I don't claim to be an expert in this area. I guess from a politician's point of view, when you have people like Governor Granholm and Joe Manchin, somebody I actually know, I don't believe in their mind at the time they signed these laws into law that they felt that that's what they were doing. Can you understand how somebody would come to a different conclusion?
Oh, of course, and I certainly don't mean to claim that legislature sat down and said, well, let's see how we can prejudice minorities in writing these laws. But sometimes, because this is a human enterprise, right. Juries are human beings, juries carry the baggage, unfortunately, this country has sometimes, the laws express themselves in various sorts of ways. Now, in terms of the statistics, I spent a lot of time it probably bored your staff senseless in terms of reading the statistical analysis there. With all respect to my friend, you asked 10 economists a question, you get 11 different responses in terms of what the data means. There's a lot of noise, I will say. There's a lot of noise in the data. But when you do see examples like Jordan and Trayvon, my only point to this committee and to the American public is that those are individuals. They're not data points. They're not statistics. They were living and breathing citizens whom we should care about. And to the degree that the law produces perverse results, and I submit to you that this result with Trayvon Martin was perverse. We don't know what's going to happen in the Macbeth case. But to the degree that's even a possibility, it's something that we should look at.
And I would just going to, well said, and I guess the point about trials, having been in the court a few times, if you believe that Mr. Martin was on top of Ms. Zimmerman and inflicting punishment, that would be a different view. If you believe that he was just walking to get candy and a soda, which he obviously was, you wonder how can somebody be dead because of that. And this is so complicated, and the one thing I don't want us to do as politicians is to take away the ability of, when it's your day in court, to avail yourself of a lawful defense that's been recognized, and the question for me is, have we gone too far?
Senator, thank you for allowing me, because that was exactly what I was feeling and wanted to present. There's been a lot of discussion of Justice Harlan's Beard versus United States, and that is clearly an objective standard. And if you look and you say, in a way and with such force, as in under all circumstances, he at the moment honestly believed and had reasonable grounds to believe were necessary to save his own life and protect himself from great bodily injury. That is exactly the problem, and that's why there's been so much prosecutor opposition to this sort of direction. The Florida law, and we stand by the verdict. As you said, there are many times there's a disappointment of what happens in court. I've handled and I've had not guilties. That occurs. But based upon the law as they drafted it, There, it's a subjective belief. What did he believe at that time was occurring versus it being objective, as well as the immunity, and that's when you get trouble. And that's also, in 2007, when I was the director of the American Prosecutors Research Institute, we published a piece on the Castle Doctrine well in advance, and in that piece, we were concerned about the racial implications, because when you go to what that person believes, and when you have such a heterogeneous population, you don't know what that person believes about another individual, especially by their skin, their age, whatever that might be. And because it's subjective, it allows them to go ahead and believe they're under danger, and hence do the dramatic thing of take a life. Thank you for letting me.
Yeah.
Sorry.
I would like to make a couple comments. One is, I mean, if you actually look at the data, look at the Tampa Bay Tribune data there, account for the different factors in the cases, you find that minorities, both blacks and Hispanics, are much more successful in raising stand-your-ground defenses than whites are. There's another point that needs to be made, and that is the ambiguity. It's one type of ambiguity has been discussed, but there's also the ambiguity that's having to face the person who's acting in self-defense. What is an appropriate amount for them to go and retreat when they're having to go and defend themselves? And the issue here might be, who do we want to deal with that ambiguity? When somebody's facing very quick decisions that they have to make in terms of life and death, do we want to make them have to bear the burden to try to figure out at that time how far they're going to have to retreat, and then make them realize that they may be second-guessed? As I have an appendix that shows a number of cases where they were second-guessed, and cases where legislatures and others thought that the second-guessing was wrong there, that may make it so somebody who really needs to act in self-defense is stopped from doing so, and thus endangering the safety of themselves or their family members that are there. And then finally, Mr. Laban, when he was talking about being able to go and have the stand-your-ground law apply, even though you may have been the initial aggressor there, he misses part of the law that he quoted, because it goes on to say you can use it, but then it puts very strict restrictions on how you can use it in that case. He says, stand-your-ground law is not available to a person who initially provokes the use of force against himself or herself unless, A, he or she exhausted every reasonable means to escape such as danger other than the use of force which is likely to cause death or great bodily harm to the assailant, or B, in good faith the person withdraws from physical contact with the assailant and indicates clearly to the assailant that he or she desires to withdraw and terminate the use of force. You know, the bottom line, I think, is pretty simple. Understand your ground. If someone initially provokes somebody else, then they're required to retreat.